good evening wherever you are in the world. My name is Jasmine, SIAC's Manager Legal, Strategy and Development, and I am pleased to be your MC for today's SIAC Indonesia webinar titled Strategies and Practical Tips for Effective Enforcement of Arbitral Awards. Our panelists today are Mr. Eri Hartiawan, Member SIAC Court of Arbitration, Senior Partner Exequatur Hamzah and Partners, Mr. Anthony Chia Nichols, Counsel Forte Law LLC, Mr. Kia Cheng Ko, Senior Partner Dentons Rodike, Ms. Nira Nazaruddin, Partner Somadi Praja and Tahir. Moderating this session is Ms. Shirley Gunawan, Deputy Counsel SIAC. I will now pass the time to Shirley. Shirley, over to you.
Thank you for the introduction, Jasmine. Thank you all for joining us today on SIAC Indonesia webinar, Strategies and Practical Tips for Effective Enforcement of Arbitral Awards. My name is Shirley, a Deputy Counsel at SIAC, and I will be your moderator for today. I'm very pleased to announce that we have over 400 participants registered for the event. So thank you everyone for joining in. And first of all, I'd like to extend a very warm welcome to our panelists who will be sharing their insights and experience on this interesting topic. And while Jasmine already briefly introduced those names, which I believe these names need no further introduction, but I'd like to give like a brief summary of the profile of our panelists. First, we have Pak Eri Hartiawan. Pak Eri is a senior partner at Exequatur Hamzah and Partners in Jakarta, in which he co-heads the Dispute Resolution and Litigation Practice Group and has the Aviation and Shipping Practice Group. Pak Eri is also the first and sole Indonesian lawyer appointed as a member of SIAC Court of Arbitration. Hello, Pak Eri.
Hello, Shirley. Hello, everyone.
And next, we have Ibu Nira Nazaruddin. Ibu Nira is a partner at Somadi Praja and Tahir in Jakarta. Ibu Nira has notable experience in representing clients in handling complex commercial disputes before Indonesian courts, as well as in domestic and international arbitration. Ibu Nira's main areas of practice include litigation, arbitration and alternative dispute resolution, general corporate debt restructuring, insurance, aviation, maritime, and shipping. Hello, Ibu Nira, apa kabar?
Hi, Shirley. Hi, everybody. I'm good here.
Thank you, Bu. And next from sunny Singapore, we have Mr. Koh Kia Jeng. Kia Jeng is a senior partner and deputy head of Dentons Rodike's Litigation and Dispute Resolution Department and co-head of the Construction and Restructuring, Insolvency and Bankruptcy Practice Groups. Kia Jeng's practice focuses on building and construction disputes as well as restructuring, insolvency and bankruptcy matters. He also has an extensive experience in cases involving Indonesian parties. Hi, Kia Jeng, how are you?
Hi, Bu Shirley. I'm good. Hi, everyone. Good afternoon, good morning, and good evening, wherever you may be.
And last but not least, we have Mr. Anthony Chia Nichols, a counsel at Forte Law in Singapore. Anthony has extensive experience in international commercial arbitration, including in the energy, oil and gas, finance, investment, and shipping sectors. Anthony is also admitted to the SIAC's Reserve Panel of Arbitrators. And he also co-wrote a very insightful bit about power of attorney for the enforcement purpose in Indonesia. So Anthony, how are you?
Hey Shirley, good to talk to you. I'm glad to be here today.
Yeah, I very much look forward to having your insight on that particular issue. So as far as topic is concerned, we will be revisiting the issues relating to the enforcement of foreign arbitral awards in Indonesia, which I believe is always relevant issue to discuss, especially given the growing popularity of SIAC as an arbitral institution among Indonesian parties. According to our statistics, Indonesia has always been in the top 10 foreign users at SIAC, at least in the last 5 years. So why this topic is really important? Although the expectation is always for the arbitration award to be honored and performed by the losing party, the reality is that the losing party may be unable or unwilling to perform the award. And arbitral awards are not self-executing by force of law. So by definition, if the losing party does not voluntarily pay or honor the award, enforcement proceedings will indeed be necessary, and the creditor will need to seek judicial enforcement by getting a court order compelling the debtor to comply with the award. And this is where recognition and enforcement come into play. And as we all know, the end product of an arbitration process, which is the arbitral award, will only serve economic values to the parties if it can be effectively enforced. Otherwise, it will only render the whole process arguably meaningless. And when a dispute involves Indonesian parties, as the respondents in particular, the awards will most likely be enforced in Indonesia because the assets of the respondents will mostly be located in Indonesia. And this will be the focus of today's discussion, starting from the key practical consideration during the contract drafting stage, the prevailing procedures for the enforcement, the recurring challenges, and of course, practical tips to ensure effective enforcement in Indonesia. Participants are most welcome to submit your questions using the Q&A function on the screen. And you might also want to indicate which panelist the question is addressed to if relevant. As we only have 1 hour, we will try our best to answer the questions during or at the end of the session. So without further ado, I'm going to start the session by asking the panelists on the very first subtopics, which is the issues to be considered by parties at the contract drafting stage. First, I would like to invite the comments from Pak Eri and Ibu Nira as the expert in Indonesian arbitration law. So when negotiating and preparing contractual agreements, what are the steps that parties shall practically consider to ensure that the arbitration clause or agreement is clear, valid, and enforceable, especially in Indonesian context or when one of the parties is Indonesian? Perhaps Pak Eri would like to give it a go first on this question.
Okay. Actually, I have already prepared a slide PowerPoint presentation. I would like to ask somebody from SIAC who could assist me to share the screen. Yeah, maybe we could directly go to page 2 of the slide, in which we discuss the most important issues when you are drafting a contract. Of course, for the Indonesian context, we have to particularly refer to the specific article in the Indonesian civil law, which provides the requirement on the validity of the contract. Of course, in the contract itself, there are also issues with regard to the location and also seat of arbitration, which in practice sometimes they mix each other. For example, that they interpret that the seat of arbitrations means that the arbitration shall be, for example, held in Indonesia, Jakarta, for example. But the seat of arbitrations is referring to how the process of the arbitration shall be conducted. And also the power of arbitral tribunal. There are also issues when the tribunal issue its judgment based not on the agreement of the parties. For example, the parties do not agree for the arbitral tribunal to issue based on ex aequo bono, but the arbitral tribunal made such decision based on such principle. So this issue is also may become an issue when it comes to the enforcement of the arbitration award, due to the the authority of the tribunal, whether they have the authority to issue judgment based on ex aequo bono. For the Indonesian context, it is also important that we know that the duration, the process of the arbitration shall be shall be completed within 180 days, 180, which I believe in the international arbitration practice, it requires more time to complete, and with regard to such a period of time, I think it should also be agreed by the parties, and also by the tribunal, that the process of the arbitration can be extended for a certain period of time. Again, for the Indonesian context, there are also a law with regard to the Indonesian language. Sometimes the issue of the language of the contract is also become the issue when it is not clear governed under the contract. I maybe pause here. Maybe Ibu Nira would have something to add.
Yeah, thank you, Pak Eri. Well, I just would like to add a little bit. First thing first, that it has to be clear and cannot be disputed that the dispute will be under the definition of what arbitration law provides, i.e., it is a dispute on commercial things. So there are several definitions which can which can define what is a commercial dispute. So it has to be very clear, and it has to be not be able to be challenged on that. And the second one is that I would like to add is that there should be a clear provision in what proceedings that the parties would like to do. For example, there is a clause that the party will have a negotiation first before it goes to arbitration. So it has to be very clear whether the party really want to have a negotiation before, because, for example, in BANI, if there is a provision about the party going to negotiation first before going to arbitration, and the party do not do it, then BANI will reject it, and I believe it will be in other institutions as well. And then that's what I would like to add. So we have to make sure about that.
Okay, so probably adding to that, I'll move to Anthony. What are the factors to be considered when selecting an arbitral institution that is best to administer the arbitration, and how does that selection could play a role in the enforcement process? Anthony, over to you.
Thanks, Shirley. I mean, I've been invited here by SIAC to talk today, so I feel like the easy answer would just be to say SIAC clauses. And of course, that is very much true. SIAC is an excellent institution, as we all know. I think the slightly more nuanced answer is that it depends on whom you're representing and what their interests are. So I think in the typical situation whereby, let's say you are representing party A against party B, both of which have similar bargaining power, there's still other dynamics to look into. For example, are you likely to be the claimant? Are you likely to be the respondent? Where is your particular party from? Which institutions, which governing laws are they familiar with? Where are you looking to enforce the award at the end? Now, without sort of explaining why each of these different factors matter, I would just say in summary that you need to look at what your end goal is, depending on all these different factors, and then tailor your clause appropriately. So just to explain that a little bit more, let's say that you're representing an Indonesian party against an American party. Now, in a situation where the American party has assets in Indonesia, right? So you represent this Indonesian party against an American party. The American party has assets in Indonesia. and you are the claimant. You're likely to sue under that contract. Now, in those circumstances, it might actually be better to choose an institution like BANI, where you as the Indonesian party are, you're going to be a lot more familiar with it. You have your suite of Indonesian lawyers who you can use in the BANI proceedings. And it will be more difficult, presumably, for the American party to participate just because of language reasons, unfamiliarity with BANI proceedings. And of course, because the assets are in Indonesia, the Indonesian courts are probably quite likely to enforce that BANI award, which makes it, again, easier for you as the Indonesian party to get the assets. But if you change the situation just a little bit, let's say that the American party doesn't have assets in Indonesia. It only has assets back in America. Well, that changes the formula. You have a different input to the formula, and it comes to a different result, I think. Because sure, you could sue the American party in the BANI arbitration, but the question then becomes, as you sort of alluded to just now, Shirley, about enforceability. And like it or not, certain institutions, their awards have a little bit more, they're considered to be better currency in overseas jurisdictions. ICC awards, SIAC awards, LCIA, HKIC, these are all very, very prominent institutions, and their awards are very good currency around the world. So in that situation where you're the Indonesian party again, likely to sue the American party, but you expect enforcement to actually be overseas in America, then in that situation, you'll probably want to choose an arbitral institution where it's whose awards are considered good currency in the place of enforcement. So I don't think there's one simple answer. Of course, SIAC is always a good choice, but it would ultimately depend on the facts of your case, who your party is, what their interests are.
Thank you so much, Anthony. That's very insightful. I think at this juncture, we can safely assume that parties should begin to plan strategically about the enforcement of the awards during the contract drafting stage, because sometimes when the parties pay attention to this issue only after getting the award, it's often too late. So in this respect, I'd like to invite Kia Jeng to give its comment. In your opinion, how important is drafting a clear and enforceable arbitration agreement in assisting the enforcement of an arbitral award, which happens at a later stage? And what are the risks that the parties may possibly encounter if the arbitration agreement is poorly drafted? Usually when parties prepare a contract, and they will usually just, sometimes it happens, they only copy and paste the dispute resolution clause from another contract without further checking whether it's relevant or not. So Kia Jeng, can I have your comments on this?
Sorry, before Kia Jeng explain it, can we ask that the PowerPoint will be off, so that.
Oh, okay, sure.
Yeah.
Thank you, Pak Eri. Kia Jeng, over to you.
Thanks, Pak Eri. Thanks, Shirley. What Pak Anthony spoke about is actually very relevant, and I wanted to talk about that because, to borrow language from the construction law parlance, fitness for purpose, you need to understand all of the considerations that Pak Anthony spoke about to be able to see what sort of clause you want in the agreement. Most of the time, people would say that the agreement to arbitrate clause in the underlying agreement is called the midnight clause. Why? Because the parties negotiate everything on money, duration, payment clauses, perhaps the governing law. Then, okay, towards the end, let's decide where do we deal with disputes when they occur. And this is at the time when things are still okay and cordial. So some people will say, "Ayah, just go to court lah." Then some people would think, why not arbitration? It's a good thing, it's confidential. And then they perhaps Google it, pick up a clause from the internet, plunk it in, and then they sign the agreement. And 2 years later, they realize that, alamak, things are not going well. We need to have a resolution of the disputes between us. And then they look back at the clause, agree at midnight, and then they realize that there are problems. There are at least two broad points that I want to make. The first is the agreement to arbitrate is the start. You need to look at the end game. What's the end game? If I feel that I should get something, be it money or some other relief, I want to ensure that it's enforceable. I want to ensure that if I go to Jakarta to have it enforced, I can get the money or get the relief that I desire. That's the end game. But if the start has brought you down a path that puts into jeopardy that end game, then there's a problem. So one needs to look at the end game to see what sort of agreement needs to be reflected in the arbitration clause. And the good part about having a dispute on enforcement is that there is delay. But it's okay, it's just delay. You get interest, yeah. The terrible part is that your award is not enforced. It's set aside. It's not given effect. Then you realize that 4 or 5 years down the road, after you started arbitration proceedings, you are left with nothing. And worse still, you may run into a Limitation Act problem. Can you start the claim now? Are you out of time? So if you look at it from that perspective, my suggestion is look at the clause that you want to set out for the agreement to arbitrate. It must be very clear. In badminton, there are rules. When you play a computer game, there are rules. There are rules that apply to any arbitration proceedings. The rules seek to give effect to due process. I'm not saying that this only applies in Indonesian context. It can apply to any context, be it an Indian party, be it a US party, a European party, if the rules of the game are liable to attack, because they are not clearly set out at inception, then it gives somebody the ability to say, hey, I didn't agree to these rules of the game. I didn't agree that the tribunal has got jurisdiction or power to do all these things. And whatever now that has been done, actually is not within the jurisdiction nor the power of the tribunal to do so. So it's very important to set out the rules of the game from inception. So for example, Pak Anthony talked about SIAC. The same principle applies to all of the major arbitration centers, including Bali, because once you choose that institute, invariably you take on the rules promulgated by that institute. SIAC, ICC, Bali, that's a very safe solution. But if you decide to not go down the route of an institution, then you need to think about what are the rules that apply. Are you going to adopt the arbitral rules? Are you going to adopt some other rules? And you must try to ensure that it's all complete or as much as possible, subject to negotiation. And then we look at the issue more fundamentally about, is there a clear and enforceable arbitration agreement? Over time, until this day, we still see clauses that refer to institutions that don't exist, clauses that don't really point to a clear mechanism for arbitration. In some jurisdictions like Singapore, we are very pro-arbitration. I've got no doubt that Indonesia is also pro-arbitration, but there will always be nuances in application. So if you were to have a clause that says, oh, let's refer to the rules of arbitration of the Singapore Arbitration Institute, there's no such entity, to be honest. There's SIAC, there are other institutions, but there's no such thing as the rules of the Singapore Arbitration Institute. If you go before a Singapore court, chances are that the court will say, okay lah, something wrong with the rules or what is to be the entity governing the arbitration, but it's okay, I can see parties agree to arbitrate. Then we go through a default mechanism under Singapore law. But I'm not sure whether if you get the award off the back of that, in a different jurisdiction, you may be able to effectively enforce, because I can see where people will try to challenge it on that basis. Just a couple of small points. Ibu Nira talked about the amicable discussion for a resolution, or broadly speaking, as an alternative mediation before parties can refer to arbitration. I think we all know in this space, it's called a multi-tiered clause. Many issues that come with it. Do you have to go through it before you hit to arbitration, or is it optional? If it's mandatory to go through it, and you don't go through it, does it become a jurisdiction problem, i.e., the tribunal has got no jurisdiction to hear the dispute until you walk through the process, and therefore it should be thrown out? Or is it an admissibility issue? I must confess, the law in different places at different times have got different outcomes, and it's still hotly debated. The current thinking from Hong Kong and some other leading jurisdictions is that it's an admissibility issue, but some other countries still talk about it as a jurisdictional issue. Then confidentiality. We all learn in law school and we speak in the market, at drinks and at SIAC. Arbitrations are confidential. But when you do a thorough sweep of the rules of major institutions, it may not always be the case. Of course, in some places, the law is such that if there's the seat, then confidentiality is more or less a given, but there are always exceptions, and that's the nature of the law. So if confidentiality is important, for example, in an intellectual property dispute, then it's important to put that down as well, so that it's there at the inception, not a problem later. But fundamentally, my advice is get qualified lawyers to help you. Don't leave it to 11:58 p.m. It's going to be a problem when things blow up. The extra time and effort that you spend at that time, working it out, is going to be probably better than fighting a jurisdictional challenge, fighting an enforcement challenge a few years down the road.
Thank you so much, Kejeng. I guess to sum up, in any contract, a clear arbitration clause is a primary key to avoiding disputes over jurisdiction, avoiding challenges to enforcement. That's the starting point. So I would like to move on to the next subtopic, given the limitation of time that we are having. I would like to talk about the fun part of the procedures of the enforcement of foreign arbitral awards in Indonesia. And for this particular part, I would like to invite Ibu Nira and Pak Eri. Perhaps I'll go for Ibu Nira first. Can you please enlighten us on the procedures that exist for the enforcement of foreign arbitral awards in Indonesia, and how is the extent of court intervention in the process? Over to you, Ibu Nira.
Yes, thank you. So enforcement of International Arbitration Award in Indonesia provide two steps. The first step is actually administrative purpose is to obtain an exequatur. Although it is an administrative process, this one is quite delicate process. So the documents that you have to prepare are quite extensive. For example, you have to get the International Arbitration Award translated in Indonesian, and then also the power of attorney from the tribunal if the lawyers or the parties have to file the application of exequatur in the court, and then the recognition that the state where the case is proceeded is the state that ratifying the New York Convention. So these two, in particular, these two documents, POA and the statement from the statement about that the state where the arbitration is proceeding is the contracting party of the New York Convention are quite not, I do not want to say difficult, but it is the process to prove to obtain them is quite it is not simple. It's something in particular because like the tribunal do not recognize that we have to get the power of attorney, or the Indonesian embassy in the state is not also is not aware and then about that they can issue a statement like that. So and then that administrative process, if it is all is approved by the court, then the exequatur will be granted. That's the first step. The second step is to do the enforcement itself. To do the enforcement itself is different regime. So how to enforce the award will be under the Indonesian procedure law, which is still under the HIR, the inheritance from the Dutch colonial. And then the difficulties actually in this enforcement stage, because there are several steps again that the party have to follow initiated with the application for unmanning. Unmanning is the court call for the losing party to come to the court and then will be reprimanded by the court that they have to pay. They have to honor the award. And the second one, another application to enforce the assets. And the third one is the application for, to execute all the assets. So there are several steps, and then none of them is the easy step that we have to really careful and then consider about taking those steps. And maybe Pak Eri would like to add.
Yeah, thank you, Bu Nira. Pak Eri, perhaps do you have further comments? And perhaps we will be grateful if you could also share with us if there's any recent legal development in Indonesia which may impact the process of enforcing foreign arbitral awards. Over to you, Pak Eri.
Yes, I agree with Ibu Nira. The enforcement of the international arbitration award is not that simple, quote unquote. But again, we have to be, we have to endorse what has been done by the Indonesian Supreme Court by upholding the arbitration clause, by upholding the arbitration agreement, and also there were discussion among the Supreme Court judges that as long as there is an arbitration clause, then the court shall be stay away from the issue. That I think a huge development in as far as the Indonesian practice context. And to add what Ibu Nira has already clearly explained is that it is also we have to be aware whether the award that will be enforced is the final award or the interim award, because Indonesian court nowadays only refers to the final award that can be enforced in Indonesia, where the interim award or the emergency or partial award cannot be cannot be enforced. So that's the I think the issue that the parties have to be aware of. And of course the emergency or partial award is not useless. It's not useless, quote unquote, at least for the party who are not enforcing the partial award or emergency award. Then the tribunal examining the substance of the case will be maybe have their consideration that such party is in a bad faith, for example, by not enforcing voluntarily the emergency or partial award. That's the issue I think we have to be aware. And the other issue is whether it comes to an insolvency. Of course, under the law, under the Indonesian bankruptcy law, and insolvency will not affect the validity of the arbitration agreement, but the enforcement of the arbitral award may be affected because as you are aware that if there is an insolvency condition, one PT company is declared under what we call it PKPU, or what is PKPU? Suspension of the payment obligation under the court order. Then the enforcement of the arbitral award in practice may be affected. So that's the area that you have to be aware of. Shirley, over to you.
Thank you so much, Pak Eri. I think that's very interesting because in SIAC rules itself, we provide provisions regarding the emergency arbitrator, which the aim is to address situation where a party is in need of emergency interim relief before the constitution of the tribunal. And sometimes we also encountered the situation where tribunal issues a partial award relating to, for instance, liability, damages, jurisdictions, costs. But apparently, those awards are still not enforceable in Indonesia, ya Pak Eri ya. Okay, so I would like to invite further comments from Kiajeng and Anthony for my next question, because I'm interested. I'm interested to know the insight from the non-Indonesian counsels. So, based on your experience in assisting clients in disputes involving Indonesian parties, what are the things to look out for in enforcing foreign arbitral awards in Indonesia? I would be grateful if you could share with us if you have encountered any practical difficulties and how do you navigate such circumstances? Perhaps I'll go to Anthony first.
Thanks, Shirley. I'll talk about, I think, the semi-elephant in the room, which is the power of attorney. So Indonesia is quite an exceptional jurisdiction in the sense that one of the requirements to enforce an award in Indonesia is that the tribunal has to issue this document, the power of attorney, to allow the parties to enforce the award in the Indonesian courts. And this is regardless of whether the arbitration is seated in Indonesia or if it's seated elsewhere. For any arbitral award to enforce in Indonesia, you need this power of attorney from the tribunal. And it's not something which a lot of international arbitration practitioners are very familiar with. So the Pak Eri, Bu Nira, Pak Kiajeng, obviously all of these people are very familiar with this. But when you start talking to practitioners, even senior practitioners based a bit further away from Indonesia, it's a very strange requirement, and they tend to be quite reluctant if they haven't come across this before to deal with this issue. And of course it has, it's required, I think, by Article 67 of the Indonesian arbitration law. And it's the first requirement to start the recognition and enforcement process. And thankfully, in my cases, I haven't had this problem because I was assisted by a very good co-counsel who brought this to our attention. And myself and one of my former colleagues, spent quite a lot of time looking into this issue, trying to understand it. What is the POA? What does it need to cover? When should it be issued? How do we get it in front of the tribunal? But I would imagine that there are a lot of other cases where this simply hasn't happened, meaning to say that the parties only became aware of this requirement at the enforcement stage, when the tribunal was already functus officio. And in those circumstances, again, it's a very real and practical difficulty, because you're asking a tribunal who has issued its award. It's functus, so it's finished its job. It's probably been paid by the institution already, and now you're asking these people to personally take on this obligation of signing a document and granting a power of attorney to lawyers when the tribunal probably doesn't even know what this is all about. So there's very much this reluctance if you get to the end of the arbitration, if you get to the award stage already, and you don't have this power of attorney. I think that the one line sort of solution to all of this is just being aware of it and working with good local counsel who can inform you of what is the power of attorney, what does it have to contain, and how do you get this in front of the tribunal's face long before they've issued the award. This is something I could talk about for days on end, but I think I'll leave it there for now and leave it to Pak Kiajeng.
Over to you, Kiajeng.
Thanks, Pak Anthony. Thanks, Shirley. I must give a qualification first. My experience in getting the power of attorney has been, thankfully, quite smooth for all the arbitrations that I've done involving Indonesia. But what Pak Anthony said are real issues. I think that there are two broad points. The first point is getting the power of attorney. And then the second broad point is timing, which is linked to functus officio. So in terms of the first, if I recall correctly, the provision under the Indonesian arbitration law is that the tribunal will need to go and register the award for enforcement, loosely speaking. First step, of course, is by issuance of the Exequatur in Indonesia. Then alternatively, it would be by somebody who's authorized by the tribunal to do so. And that's why they got the power of attorney. Invariably, the tribunal will always issue a POA for that purpose. The POA has got certain formalities. If it's going to be executed here in Singapore, it needs to be before a notary. And then there is a side issue of whether or not you need to go to the Indonesian embassy to get it legalized and all the other formalities. So if your tribunal is unfamiliar with this process, not so familiar with what is the requirement in Indonesia, then there will be a lot of questions. And the longer this process drags out, then there may become the argument about functus. There was a theoretical issue in my mind about should you get the POA before or after the award is issued? If you go on strict functus officio reasoning, then assuming that all of the issues have been determined by the tribunal, and therefore the tribunal is functus, then you should be highlighting this need to get the POA before the final award, loosely speaking, because there can be a final award on merits, there can be a final award on interest and costs. But you should be getting the POA or flagging out the POA before the final award is issued. But the problem is, at that juncture, who is the Indonesian attorney who is going to be authorized to go and do the enforcement there in Indonesia? Then if you get the POA after the final award is issued, then you run into a real problem about arguments regarding functus. Thankfully, in my cases, I didn't really have to deal with that. So I must confess, I don't have good experience myself on this. But these are arguments that can be run by very good counsel, if of course they have got a particular strategic objective. Then there is the related issue, and again on timing. As I understand it, under Indonesian arbitration law, a domestic award needs to be registered within 30 days. For a foreign award, the enforcement process doesn't really have a timing provided in the arbitration law. I don't think it's correct, but once upon a time, I've heard advice from Indonesian counsel that, hey, to be safe, you better go and do the application within 30 days. Then there's a problem, because if I don't get my POA within time, then I may be faced with an issue that I can't even really enforce the award there. I don't think that's correct, because if you go on the conventions, as it were, the model law, there are certain time processes which are provided there for a setting aside, which is of course different from enforcement. But under domestic Indonesian arbitration law, there may be a timeline where you can enforce, but I'm just not entirely aware of a direct timeline for that compared to the domestic award situation. But of course, if Pak Eri and Ibu Nira can share with us their experience on this front, I think that would be great. Quite apart from the POA issue, there are other things, for example, that we always see. A tort claim commenced in Indonesia before the courts to either delay or to try to strategically upset the enforcement process. In the early days when I started practice, I do see quite a fair bit of that. In more recent times, I still see some of it, but anecdotally, I understand that it's not that common nowadays compared to previously. I'm not saying that it has completely disappeared, but the percentage of it overall seems to have gone down a bit. But that's what I hear from the grapevine. But it is very common for the tort claim to be brought to kind of frustrate the enforcement process from my experience as Singapore counsel.
May I comment on?
Sure, Pak. Sure,
yeah.
Pak.
Yes, the power of attorney becomes an issue for the enforcement of the international arbitral award. But I think we have to see what has been practiced in the Indonesian domestic award enforcement. If we revert to Bani's award, for example, there are a specific order from the Bani tribunal for the secretary to make a registration. Therefore, with such clear order, then the power of attorney will no longer be required because it has been put in one of the Bani's decision, Bani's award, for the secretary to register it. So I think that practice can also be considered with SIAC or other international institution to, you know, I mean, maybe to amend the rules to give also the authority for the tribunal to give the not the power of attorney, but the order to the secretary of the tribunal to make such a registration. And therefore, you know, the problem we face nowadays with regard to the how long that we've got a proper power of attorney signed by each of the tribunal will no longer be the case. Maybe Ibu Nira would also add something, please.
Well, it's a very good suggestion actually, because it will be really helpful for us, and it can, you know, it can cut off some time and then some problems with regard to the registration, because as I said before, it is just an administrative process actually. To obtain an Exequatur is just an administrative process, but for the losing party, actually this stage is the stage that they can play off. So how to frustrate, how to delay, and they can begin from this stage. So I think if we can get an outcome or assistance from another institution to have instruction or order like that, I think it would be very helpful for us.
Yeah,
Sure.
Oh, sorry. You first, Anthony.
Thanks, Pak Eri. Shirley, I think this is the time where I need to earn my invitation to the SIAC's panel today, because I'm going to defend the SIAC here.
Sure, go ahead, Anthony.
So Pak Eri very, very rightly mentions that in Bani arbitrations, there is a step which the institution itself takes to ensure that this registration, that this POA requirement is satisfied. In the SIAC's defense, unlike other institutions, you know, one of which might be based in Paris, the SIAC, when it has an Indonesian-related arbitration, it actually sends a letter to the arbitrators at the outset of the case. And one of the points that it mentions in these appointment letters is this requirement of a POA in Indonesian arbitrations. So the SIAC does do some, you know, it does more than other institutions in that sense to bring this to the tribunal's attention. I would also say that in my practical experience, I've actually seen a difference between different institutions as to how much assistance they will give the parties and the tribunal in the course of the arbitration when it comes to this POA issue. Again, historically, I believe, but perhaps someone from SIAC can confirm this, I believe the SIAC actually used to give a draft POA to the tribunals, or at least bring it up, you know, to their attention. That, I mean, you can confirm or you know, infirm that, but that's what I was told at least. The second point I wanted to mention is it partially relates to one of the questions which was asked in the Q&A section, which is, well, you know, if you're not dealing with a Bani arbitration where this POA issue is addressed already, and if the tribunal hasn't been informed by the SIAC or a different institution, how do you bring this to the tribunal's attention, before the award stage? I think the most practical step that I've seen is to actually include the issuance of a POA in your requests for relief. So, in addition to all of your other points, you say the claimant or respondent requests that the tribunal issue a POA as, request 6 or whatever. And so in the course of the arbitration, the tribunal is forced to look at this and say, okay, look, what are we talking about here? What is this POA thing? And it's at that stage where you can then give them the draft POA. They can review it and say, okay, why do I need to issue this? What's the scope of the POA? What happens if I don't issue it? I feel like that's a lot, it's more of a direct, and it sort of forces the tribunal to address this issue, as opposed to it just arising at a much, much later date. The third and very, very final point is that, the person who I wrote this article about the POA with his name is Dimitris Katsikis, is a good friend of mine. And while writing that article, we actually drafted a template POA that we were thinking of publishing one day. If with the SIAC's I don't know, blessing, if that's possible, I'd love to circulate it after this webinar, so that participants here and also tribunals in the future can perhaps use that as a reference of what a POA can look like. But again, I'll maybe discuss that with you afterwards, Shirley.
Sure, thank you so much, Anthony. Well, SIAC does not provide any draft of POA, but of course we can contact Anthony since he already offered to circulate one. But yes, but from the institution perspective, we try our best to raise this issue with the tribunal at the early stage, like Anthony mentioned. So I think Jajang and Ibu Nira mentioned about challenges before. So perhaps I would like to circle back to Ibu Nira about the strategies commonly used by the party to challenge and frustrate the enforcement of foreign arbitral award in Indonesia. How does that work in practice? And perhaps you could share with us any tips to strategically and effectively navigate such challenges in the enforcement process?
Yes, well, the tips is basically to have all the arbitration award are clear, and then all the documents are properly prepared before you go to the to apply. So the challenge can be taken in the stages of the obtaining Exequatur. In practice, there are two challenges that they usually do. They are usually doing is, first, they write a kind of letter, but we can or application while the Exequatur is still in process. So, well, actually, Exequatur is an ex parte process. So it is really depending on the court to issue it or not. But we have some experience that the losing party files an application saying that actually it cannot be enforced. Usually it is because of it is against the public order or public policy under Indonesian law. That's the first step. The second step, when the Exequatur is issued, then they file a kind of a case, a civil suit against the party or against the institution that issued the award. There is another challenge that they file what we call it Deldenverzet. It's a challenge claim against all the contents of the International Arbitration Award. So, and then the challenge can be for them to just to ignore it, and the second one is to annul. But I think for annulment of application for annulment of arbitration award, I don't think it has never happened in granted in Indonesia, because as Pak Eri said before, that Indonesian court honors the arbitration award, and the Supreme Court has ordered that if there is, arbitration clause, it cannot be. The court has to dismiss all the cases against the International Arbitration Award. That's what happened here. So that's the tactics from the losing parties if they would like to challenge the arbitration award. Well, yeah, as I said, there is no specific tips for that, because the reasons can vary, and then the losing party has usually has a very creative arguments to file the challenge. So what I can suggest is that please prepare all the documents since the beginning, very early. Do not miss anything about the documents. For example, like power of attorney, or whether it is against public order. We have to define that it has to be clearly a dispute on commercial matters, and there is no Indonesian law has been breached. That's the general tips for that.
Thank you, Ibu Nira. Following Ibu Nira's comments, I would like to invite further comments from Pak Eri. In your experience, Pak Eri, how do courts in Indonesia typically respond to the challenges of foreign arbitral awards?
Well,
perhaps do you have any insight from any recent case?
Yeah, I agree 100% with Ibu Nira on the losing party try not to enforce by doing some acrobatic, I call it acrobatic. But again, the magic word for in this context is the due process of law. Once we've got this due process of law during the process of the arbitration, then I think it is very, very difficult for the losing party to not to enforce it, and it is very difficult also for the court not to accept the enforcement, because well, the process of the arbitration is fulfilling all of the principles, particularly the due process of law, and I think that would be the ammunition for the winning party to always argue that, hey, this is the valid and proper process of the arbitration, and the arbitral award has already been issued based on by enforcing, by upholding all of the principle. For example, the Audi et altram principle, that the party has the right to be heard and everything, and also other general principle that must be done by during the process, because the only reason for the losing party to again object on the enforcement of the international arbitral award is the as Ibu Nira clearly mentioned as well, the public policy. There is no clear definition on the public policy under the Indonesian law. So, it can be interpreted by anybody, unfortunately. But again, if we revert to the certain jurisprudence, for example, I also involved in the men's sugar case at the time. It was back in 1990. That there is an arbitration clause, and the court accept and examine and make a decision on the lawsuit filed by the party in Indonesia, arguing that the contract is invalid under Indonesian law. The contract itself is filed under a tort claim, not a breach of contract, but tort claim, and it has been examined and then decided by the Indonesian court. So those kind of deviation or modification or extension or of the definition of the public policy is become a concern because there is not a particular or definitive definition on that public policy. But again, we have to go back to the process when we have or when we prove that the process has already been implemented by upholding the due process of law, then we don't have to worry too much on the enforcement of the international arbitral award. Over to you, Shirley.
Thank you so much, Pak Eri and Ibu Nira, for the insightful tips and explanation. So my next question is actually quite similar to one of the questions that's raised by one of the participants. In light of the COVID-19 situation, there has been an increasing use of virtual and electronic procedures, including hearings. Do you think that there will be more challenges to arbitral awards on grounds that relate to procedural fairness, where the hearings have been conducted remotely? And do you, by any chance, have any tips to navigate such instances? Perhaps I would like to invite Kia Jeng and Anthony for this question. Kia Jeng, over to you.
Sure. Thanks, Shirley. Anthony, don't mind if I just talk about it first.
Oh, go
ahead. It's true. With COVID-19, there have been a lot of cases that had to be done by Blue Jeans or Zoom. I must confess, the facilities for that are fantastic from having been able to use them. I think that there is a possibility that the losing party may challenge the use of technology to do hearings virtually. But I am optimistic that such challenges probably will not be successful. And the reason is this. The virtual hearing is a mode of getting the evidence. Of course, people can argue to the cows come home about whether cross-examination of witnesses is better if done in person compared to over Zoom. But the concept is that it's just a media for evidence to be led, arguments to be proffered, and it doesn't significantly take away one party's right to be heard, as Pak Eri said, audi alteram partem. That may be very different from saying that it will be a documents-only arbitration. Of course, if parties all agree to do documents only, then no problem. But if it's not agreed expressly, there are some arguments that you can't do a documents only, there must be a hearing. Then how the hearing is to be conducted then depends on what are the rules of the game. If the rules of the game give discretion to the tribunal to determine after hearing parties that the virtual hearing is suitable, then I think it probably would be able to withstand scrutiny and challenge. It again goes back to due process. I think a concept that we've been talking about throughout the past hour. What we have done, and I think most practitioners, including Pak Anthony, has done as well, is that when we were looking for a virtual hearing at the time in 2020, there were protocols floating around on Google. There was a SOL protocol, there was certain guidance notes from SIAC, there was certain guidance notes from the ICC. And what we did was that we suggested all of the protocol, of course, directed as well to the respondent, where we are claimant and vice versa, and sought their views. And in the end, everything was presented, or even if the other party did not appear or appeared but disappeared after a while, they were given the opportunity to consider and provide their comments. And if the tribunal, assuming that the tribunal has got such power, decided on doing a virtual hearing, then it's within the jurisdiction and powers of the tribunal. So again, it goes back to what was the agreement? Does it exclude virtual hearing? If it's silent, is the tribunal, based on the rules, empowered to do a virtual hearing? If the tribunal is empowered, walk through due process to make sure that whatever protocols that you want to suggest, a plan B in case the connection drops, all of that would need to be proposed and ventilated, or given the opportunity to be ventilated. And after you walk through the due process, I do suspect and I'm optimistic that a challenge based on just the virtual hearing argument is probably not going to succeed from my perspective. Sorry, I took some time, Anthony.
Thanks, Pak Kia Jeng. I actually wanted to pick up on one point you mentioned at the very beginning of that answer, which is that the losing party will use any excuse to try and set aside an award. And I think we've all seen that in practice. The use of Zoom or other virtual technologies to conduct a hearing will no doubt give rise to challenges. There have been challenges in the past, in fact, in 2020. The Austrian Supreme Court was faced with this issue. Is it inherently unfair? Well, not unfair, but was an award which came about after a virtual hearing, was that enforceable? Should it be set aside? Sorry. The Austrian Supreme Court said no, the award was fine. I think the High Court of Australia or one of the federal courts over there has likewise addressed this issue of virtual hearings. And the jurisprudence so far is very much in favor of virtual hearings being an alternative to in-person hearings, as long as the safeguards that Pak Kia Jeng was mentioning just now are satisfied, as long as the parties have an opportunity to be heard, as long as there are no other inherent procedural problems with it. In the context of such an attack on award being brought in Indonesia, I mean, I think Pak Eri and Ibu Nira would be better placed to address this, but the New York Convention and also I think the Indonesian arbitration law, I think Article 29 of the arbitration law requires the parties to have an equal opportunity to be heard. There's no reason why they wouldn't have that by a virtual hearing. One thing I noticed about the Indonesian arbitration law is that there's actually an Article 37.2, which talks about the possibility of having witnesses testifying from a different location from the arbitration, I think from the seat itself or from the venue. And I believe that this provision probably was to help tribunals, have a venue in one place, even though the seat was elsewhere. But there are provisions in the arbitration law which I think could be used to mount a very good defense against an application to set aside an award purely on the basis that it's a virtual hearing. And if Indonesia were to be the jurisdiction which says no virtual hearings whatsoever, that's inherently against due process, I think that'd be a pretty bad step. It wouldn't really help it wouldn't help to give parties confidence of seating an arbitration in Indonesia.
Thank you so much, Anthony and Kia Jeng. Perhaps I would like to invite Pak Eri for comments. Do you expect that there will be instances where the losing parties will seek to resist enforcement on the basis that virtual hearings denied an alleged right to physical hearing? And will such challenges be likely to succeed in Indonesia, Pak?
Yeah, for your information, Shirley and everyone here, Indonesian Supreme Court already issued many, well, it's not that many, but several Supreme Court regulation concerning the e-court. Lastly, what has been issued by the Indonesian Supreme Court is the e-mediation, electronic mediation. So, and also for the criminal case as well, the Supreme Court issue a particular Supreme Court regulation on the examination of the criminal cases. For the civil case, yes, we have now the e-court submission of the document. Our brief is no longer by hard copy, but by submitting the PDF version of the document. But I may say that it is now still hybrid. Although the Supreme Court already issued the e-court regulation, but in practice, the court, the judges in the district court level still requires the parties to attend, particularly for the cross-examination of the expert or factual witness. So I guess it is now the practice in Indonesia is hybrid with regard to such electronic hearing. Yeah. For the arbitration itself, the issue is more on the confidentiality. I discussed it with the chairman of the BANI, Pak Anang Garusdiono, at the time. An informal discussion with him, and the issue is, more on the confidentiality. Whether, for example, in one room, it is, sterile from other third party, not invited third party attending in the same room, for example, something like that. That the Indonesian arbitration, I mean, particularly BANI would consider that it must be with the full consent of the parties to make a virtual hearing, and also the confidentiality that must be guarded by all of the parties, including the tribunal. Over to you, Shirley.
Thank you so much, Pak Eri. So I'm going to pick some of the questions from the participants. And there's one question that quite intrigued me personally. But perhaps Pak Eri or Ibu Mira, or perhaps Kiajeng and Anthony as well. This is regarding the format of the POA. Can the POA for enforcement be issued as an annexure to the final award rather than a separate document? If the answer is yes, does the POA in that case still need to be legalized accordingly in the place of signing? Perhaps you could also mention about the Apostle Convention as well. I would like to hear some updates in that regard. So perhaps Pak Eri or Ibu Nira?
Maybe Ibu Nira first. Silakan, Ibu Nira.
Well, yeah, there is no definite form of how the power of attorney is issued for International Arbitration Award. But as Pak Eri has said before, in BANI, the power of attorney is not a power of attorney actually. Is an order is in the body of the award itself. So at the last paragraph, the order is stated there. So the arbitrators have ordered the secretary to file it. So maybe to file this award to the court. So maybe that I think that's the ideal, a form of power of attorney or whatever it is called order to grant a third party. Either it can be the secretary, or either the other the parties, or the legal counsel of the parties for the application for the Exequatur. And there is another thing is it is a separate document. We have an experience that we have the power of attorney in a separate document from the word itself, but it has to be provided during the process, so before the case is closed officially. The power of attorney is a very simple sentencing. So it's just to give the power to this to file it at the Indonesian District Court. That's it. Maybe Pak Eri would like to add?
Yeah. Firstly, the answer is no, because as you are aware that there are certain requirements for the power of in practice and also by law, that it has to be duly executed. The power of attorney has to be duly executed. There are also additional requirements that it has to be authenticated by embassy where the document is signed. For example, in UK or in Singapore, it has to be authenticated or legalized or consularized by the Indonesian embassy in Singapore or UK. So there are formal procedure that needs to be required. So if I refer to Shirley's question that whether it can be only annexed with the arbitral award, and the answer is no. I think it is, yeah, again, I refer to my previous explanation that Banis practice for Banis tribunal to make an order to the secretariat of the tribunal. I think that would be something that can be done, and that is something that maybe will be considered in terms of international arbitral award. Over to you.
Okay, I guess we received a lot of questions, and unfortunately we are running out of time. But thank you so much to the panelists for the insights, and the audience, the participants, for staying with us throughout the session. Now I'm going to give it back to Jasmine. Thank you so much, everyone.
Thank you to our panelists for the very engaging and insightful session. We hope you enjoyed the session, and we hope to see you at our future SIAC events. Thank you once again for joining us today. Have a lovely day or evening ahead, everyone. Thank you.
Thank you.
Thank you.
Thank you, everyone.
Thanks, everyone. Bye-bye.
Thank you, everyone. Have a nice day.